The Migration Act and boat refugee. Australia's geographic location is unique. All people have to arrive by regular air or sea routes. Therefore, it is easy to control and monitor its airport and ports by a visa control system. Section 42 of the Migration Act 1958 provides that a non-citizen must not travel to Australia without a visa that is in effect. The Act specifically mentioned the term travel, not arrive in or enter Australia. Any person who travels to Australia without a valid visa is unlawful. According to Section 43, a visa holder must travel to and enter Australia by a port or pre-cleared flight. If a visa holder enters Australia in a way that breaches the condition, then the visa will be cancelled. Any non-citizen who are in the migration zones of Australia without a valid visa must be detained. Therefore, if both refugees arrive into Australian territory without valid documentation, they will be not protected but will be prevented from arriving into Australia. This is arguably totally contradictory to the humanitarian spirit of international refugee law. Thus, the relationship between the Migration Act and international refugee law isn't only complex and fraught, but also challenging. Moreover, Section 5 of the Migration Act 1958 exercised the territory of Christmas Island, the territory of Ashmore and Cartier Island, and the territory of Cocos Keeling Island from the migration zone. As a consequence, any unauthorized non-citizen who attempts to enter Australia via one of these islands isn't permitted to make an application for refugee status. This is a clear signal that unlawful refugee boats are not accepted in Australia. Under the Migration Act 1958, a traveler to Australia must come via a specific airport or port road, so arrival through an unrecognized road isn't acceptable, and therefore an asylum seeker will not be able to apply for a protection visa. This law and policy contradict the term of Article 31 of 1951 Refugee Convention, which ensures that refugee will not be penalized for his or her illegal arrival. The Migration Act 1958 also includes provision on immigration detention. In the case of an unauthorized maritime arrival, where a non-citizen arrived in the Australian migration zone by sea, the Act also gives power to a security officer to prevent certain persons from entering or landing in Australia. In particular, Section 249 1AA states that an officer may prevent a person from leaving a vessel on which the person arrived in Australia if the officer reasonably suspects that the person is seeking to enter the migration zone and would, if in the migration zone, be an unlawful non-citizen. Both refugee cases are considered under a fast-track process due to being unauthorized maritime arrival. Under the fast-track procedure, any review application of a boat arrival case isn't considered by the normal administrative appeals tribunals or AAT, but by a distinct Immigration Assessment Authority or IAA. The fast-track process raises two critical issues. First, applicants have no right to an oral hearing by the IAA, and second, there is no mandatory requirement on the part of the reviewer to consider fresh information from the applicant. The main purpose of the IAA is to ensure an efficient and quick mechanism from Australia's point of view. However, the quick process and the limitation of fresh information in the procedure for review of a refugee application is arguably contrary to natural justice. The UNHCR notes that refugee status determination procedures should be based on fair standard and consistency in decision making, with domestic laws and policies framed fairly and non-arbitrarily to ensure the rule of law. Not surprisingly, Australia's fast-track process has led to criticism that it is unfair. Unauthorized maritime arrival and the Maritime Powers Act. Australia has a large maritime jurisdiction, and as a coastal state, it has exclusive jurisdiction not only over its land territory but also over its territorial sea. Contiguous Zone and Exclusive Economic Zone or EEZ, according to UNCLOS 3. Accordingly, unauthorized or illegal maritime arrival are considered a threat to the state. If both refugees arrive in Australian territory and are allowed to disembark, then they undergo a comprehensive and detailed assessment process, including security and health check. Unprocessed boat arrival may be a risk to national security. If they do not go through the refugee determination process, they may be excluded on the ground of involvement in crime or disease. They may also cause socio-economic problems, tension between migrants and locals, encouragement of smuggling-related organized crime, labor exploitation, and sexual crime. To regulate the unauthorized maritime arrival more strictly, the Maritime Powers Act 2013 was adopted for the administration and enforcement of Australian laws in maritime areas. Application of the Act extends to every external territory. The provisions of the Maritime Powers Act are in addition to any other law of the Commonwealth. An officer may exercise his powers in the contiguous zone of Australia to investigate a contravention of a custom, fiscal, immigration, or sanitary law prescribed by the regulation that occurred in Australia, or prevent a contravention of such a law occurring in Australia. The Act also empowers monitoring of compliance issues of foreign vessel or person on foreign vessel. The exercise of power includes a nationality check of a vessel, seizure of border control truck or planes, ensuring maritime safety of all, and investigation of a contravention of a custom, fiscal, immigration, or sanitary law. In addition, Section 50 of the Maritime Powers Act permits maritime powers to be exercised in relation to boarding and entry, information gathering, search, to seize and retain things, to detain vessel and aircraft, to place, detain, move, and arrest person, and to require person to cease conduct that contravenes Australian law. Under Section 69, a maritime officer may detain a vessel or aircraft. Under Section 69, 71, and 72 of the Act, a maritime officer may detain a person and take the person to a place in the migration zone or to a place outside the migration zone, including a place outside Australia for unauthorized arrival. After analyzing the provision of the Maritime Powers Act 2013, it is revealed that the Act confers extensive authority on maritime officers in relation to unauthorized maritime arrival. This Act is especially targeted to stop boat people and to authorize the interception of refugee boats. The Act contained a single legislative arrangement for all maritime powers. Nicholas Gaskell rightly points out that the Act tries to make full use of the rights given to a coastal state by UNCLOS 1982, but only in territorial waters, but also in the contiguous zone, while somewhat skirting around humanitarian obligation including that of non-refoulement set out in the Convention relating to the status of refugees 1951. Thank you.